How can I keep my estate private with a living trust? I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. Clients often ask us about privacy. They don't want all of their family business to be public after they've died. They don't want their estate, their legacy to be public. And one of the things about planning with a will or having no plan at all is that it guarantees when you die that your estate will go through a court process called probate. And as you know, courts in the United States are public. So that information that resides in that probate court file is public. And it used to be that those were paper files. And so in order for someone to know what was contained in the estate and who was getting what, they had to go down to the courthouse and ask the clerk to see the file, and then they could make copies of it, etc. So the information was public, but there was a little bit of a hurdle in getting that information. Now a lot of probate courts are online. And so you can simply open up the web browser to the court's website, pull up an estate, open up the will and read the contents of it. And there may be other filings in that probate. So there could be an inventory of all of the assets. There could be information about the beneficiaries, etc. And so what happens now sometimes is that scammers will get that information and they'll contact the beneficiaries with various different scams and schemes and, try to get a hold of some of that money. So there is a valid concern around privacy with respect to your estate. I want to make it clear that a living trust is not 100% private. It is private in the sense that when you pass away, your estate does not have to go through a probate. So there's no public court proceeding. However, when you create a living trust and you put assets into that trust, the movement of the assets into the trust some of that is public. So let's take a specific example. So let's say that you own a personal residence and you create a living trust and you move that personal residence into the trust. You're going to have to file a deed at the courthouse that says, I, Mike Smith, hereby transfer this property into the Smith Family Living Trust, for example. That deed, in order to be valid, is filed at the courthouse. That means that anybody who wants to can go down and pull that record from the court clerk and see that I've transferred my house into my trust. That is a public record. So that type of transaction is not totally private. Even moving things like financial accounts into the trust is not 100% private. So there are steps that you can take to make things a little more private. One is that, and there could be complications around this, but one potential solution would be to create an LLC and transfer your residence into the LLC and then into the trust. Sometimes you could transfer that property to a trusted third party and then have them transferred into the trust. You could name your trust with a name that does not reflect any information about you. You can name a third-party trustee and then transfer the house into the trust. And so if, for example, your lawyer were serving as the trustee of your trust and you had the Force Be With You living trust and your lawyer transferred the property into the trust, then that makes it a little more private. It's not 100% hidden from view, but it's a little more private. But because you owned that personal residence in your personal name, any way that you transfer that into your trust or into another entity, there's going to be a public record that some sort of transfer was made. And if something happens down the road and someone's looking for that information, they'll be able to find it. So if there are privacy concerns, there are some other tools that we use besides living trust to hide those assets from public view, not in any sort of nefarious way, but just to avoid being a target for someone. There are ways that we can do that. There are different types of trust that we can use to keep things a bit more private. So your trust, your living trust, is private in the sense that no public probate is required when you die. And when we transfer assets into it, we can make the steps that we're taking to transfer that a little more attenuated, a little more hidden in a way that makes it a bit more private than if you just own those assets individually in your own name. So I'm Mike Smith, estate planning attorney with Smith Barid LLC, and I appreciate you joining me today. I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now we're posting 3 videos a week with lots of information information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click below to subscribe, and click right over here to watch the next most relevant video about estate planning. Go watch it now.